not Greg, by the way. And it's based on the parties involved and their geographical location. For example, a defendant's resident or business operations can establish personal jurisdiction. Subject matter, and by the way, this could vary between state and federal forms as well. And again, you want to always go back to the rules. Subject matter jurisdiction governs what the court can hear or the legal issue or dispute being sued about. It's based on the type of case being heard. For example, subject matter jurisdiction can be limited to cases relating to a specific subject matter, such as a violation of federal law or the United States Constitution. So they're talking about federal law in here. But a court must have both personal and subject matter jurisdiction to hear a case. If a court lacks subject matter jurisdiction, it can't pass judgment on the case, and it must be dismissed. There's our magic word again. What's our magic word, everybody?
Must.
Must. Goes without saying. So now, however, a case may proceed for personal jurisdiction, even if there's a lack of subject matter jurisdiction, as long as the defendant doesn't object. And this is where I think a lot of people are caught right there. Anybody got any questions as to what we just read?
I got a question.
No.
Okay.
So, and like, for example, my case, because I keep thinking, the court's ability to hear a case, but I was a petitioner and I was motioning for custody. But in the final order, they came out with a custody and support. So my argument was that they didn't have subject matter jurisdiction to give the order for the support. Now the question is, does that make sense?
Well, here's where the issue is. The question is, can the court hear an issue that wasn't properly raised in the court? In your time sharing or custody, wherever you call it in Minnesota, was there a request for support, or was the issue of support raised?
No, so I was, like I said, I was a petitioner, and the only issue that I raised was custody.
Did she counter it in her answer and
Yes,
counter it, and also ask the court to award
support
if the court deems necessary or whatever it is, any other court deems proper and whatever, however they write that stuff up, right? Am I correct when I say that?
Yes.
Okay.